Police can always go into a house if they saw someone going inside or if they already had an arrest warrant. The reality, officers cannot just barge into someone's house, even if they have a valid arrest warrant or they may know that the person's inside, unless they meet certain conditions. This is really important because the Fourth Amendment's standard for privacy and protection for your home is the strongest of anywhere else in the country. In the Supreme Court landmark case of Payton versus New York, the Supreme Court held that officers, if they have a valid arrest warrant, can enter into a suspect's home if it's the residence where they live, if they have good reason to believe that that suspect is in the home at that time. But, and this is a very important but, this same rule does not extend to homes of third parties. In other words, if the person listed under the arrest warrant is actually in another person's home, that is not enough for an officer to use that arrest warrant to barge into this other person's home. In that situation, cops are going to have to get a separate search warrant for the third party's home in order to go in and look for the person. So let's break this down very simply. The Payton rule basically says that if cops have a valid arrest warrant, they can enter into that same person's home, their residence, and they don't need their consent. They can enter into that home as long as they believe that individual is in the home at that time. This even applies to minor offenses. This can be both felonies and misdemeanors. The court made no distinction between this as long as they're a valid arrest warrant.